Next slide, what it is mentioned, distinction between a contract of guarantee and a contract of indemnity. Let me first read out this particular slide. There are three parties, the principal debtor, the creditor and the surety. The liability of a promisor is primary and independent in a contract of indemnity. In a contract of guarantee, the liability of the surety is secondary, the primary liability being that of the principal debtor. In the case of guarantee, there is an existing debt or obligation, the performance of which is guaranteed by the surety. In case of indemnity, the possibility of any loss happening is a contingency against which the indemnifier undertakes to indemnify. In a contract of guarantee, after discharging the debt, the surety is entitled to proceed against the principal debtor in his own name, while in case of indemnity, the indemnifier cannot proceed against third parties in his own name unless there be an assignment in his favor. So after reading out the details of this particular slide, what it can be said as indemnity accordingly to the Indian Contract Act 1872, it can be said as if there are two parties, then the indemnifier and the indemnified can be said as, it can be said as the contract under section 124 of the Indian Contract Act. But accordingly to the section of 126, guaranteed can be defined as in indemnity, that in a contract of guarantee there are three parties and not two parties. In indemnity it can be said as two parties, but in case of the contract of guarantee it can be said as a three parties, that is debtor, creditor and a surety. But in case of the indemnity it can be said as two parties. It can be said as indemnifier and indemnified. So the main difference among these two points that can be said as contract of guarantee and a contract of indemnity, it can be said as, this is important for you to understand. Why? Because the contract of indemnity, it is basically based on how the legal provisions governs the contract of indemnity, and also how the contract of indemnity, it provides a security and a protection against any type of loss that can get occurred by the or through the conduct of the promisor and also through the conduct of any other individuals. And contract of guarantee can be said as what? Under the Indian Contract Act can be said as contract of guarantee, surety, principal debtor and creditor. It is based on these parties. So the main aim it can be said as, or the main purpose, it can be said as the contract of guarantee, the main purpose is to provide the additional protection and the security to the creditors, so that the individual's money will be paid back by the surety if the debtor makes any type of the default or default attitudes. So it is based on the three parties, surety, principal, debtor and the creditor. So the main features which can be said as that contract of guarantee, it can be oral or written, and also it must be a principal debt, and also it should be it should be based on the principal debtor, on how the principal debtor promises to make the payment to the creditor and how it gets maintained through the surety and how the surety undertakes for paying the creditor within the particular event, the default of the payment or the default payment amount through the principal debtor. So the consent of the surety, it will have to be said that, or it can be said that the consent of the surety should not have been obtained through misrepresentation of the material facts or related to the material facts. So this can be said under this particular slide that is been shown over here under this particular information of this particular term. Now we will be going to our next particular slide.